We were studying in the earlier class we had started about the prospectus, and now we shall be continuing about the new procedural rules which are required for the prospectus. So in that we shall be continuing with the next point. Simultaneous issue of different securities is permissible. As a general rule, no fresh issue of securities can be undertaken unless the previous offer of securities has been withdrawn or securities have been allotted pursuant to the said offer. It is now stated that there can be simultaneous issue of more than one security if there are different securities. Example, issue of debentures and equity shares can take place simultaneously. The 200% limit is to be reckoned for each kind of security individually. Means what? That the for earlier in the earlier act they had stated that the issue of securities can be done only for one case. Means only either you issue shares or you issue debentures or you issue other securities. But now here they have given the permission for providing different securities at a same time. So there can be issue of debentures, there can be issue of equity shares, and they can take place simultaneously, provided the company shall follow the limit of having 200% limit to each kind of security. No right, no no right of renunciation. The offer letter shall be issued to specific persons and they shall not have the right to renounce their right to subscribe in favor of other person. So what do you mean by no right to renunciation? Means what? Once the offer letter is issued to a specific person, he shall not have the right to renounce. Renounce means to subscribe in favor of other person. Means what? If I suppose if I have a offer letter, I cannot give it in the name of my father or my mother, I or a third party which is involved in the company, because that shall create a mess with the company. No minimum allotment size. The PAS rules earlier specified that the minimum investment size shall be rupees 2000 in face value of securities. This condition is now removed. No, there is no minimum allotment size. Why there is no minimum allotment size? Because the value of investment shall be 20,000 in face value of securities, which was there in the earlier act, has been removed, and they say there is no limit now. Relevant date for valuation. The price of the security should be arrived at as of a date which is at least 30 days prior to the scheduled date of the general meeting approving the issuance. What does this mean? Relevant date of valuation means what? Whenever the date is issued, in that case 30 days prior to the date a general meeting shall take place, and there shall be a proper date and time decided for this purpose. Then change in disclosure requirements. Private placement offer come application letter offer letter. Through this new provision, the erstwhile private placement offer letter has been replaced with the offer letter. A company is required to issue the offer letter in form PAS4. The new form prescribed for the offer letter expects extensive disclosure requirements in addition to the items covered in the erstwhile private placement offer letter. Disclosures covered in the explanatory statement to the general meeting and the financial position of the company have to be made in the offer letter. Further, while the PS rules have introduced certain additional disclosures for equity linked instruments, to the extent such disclosures are not relevant to NCDs, the scope of its applicability has been clarified. Though the disclosures have been increased, it is to be noted that the offer letter is no longer required to be filed with the ROC or SEBI. So these offer letters or these private placement are not required to be filed with ROC or SEBI, but a disclosure has to be made about the NCDs, that is the non-convertible debentures, and other whatever details are prescribed by the Companies Act. Incremental disclosures in the offer letter. In addition to the disclosure requirements under the erstwhile pass rules, a company undertaking an unlisted or listed private placement of NCDs or qualified institution placements of securities shall have to disclose certain additional information. Some of the key additional disclosure include information pertaining to default in filing of annual filings under the act and rules made thereunder, class and names of the proposed allottees, and the percentage of the post private placement capital that may be held by them. So class and names of the proposed allottees, and the near percentage of post private placement capital that may be held by them. Then change in control pursuant to the private placement. Whatever has changed after the private placement shall be mentioned. Then the number of persons to whom allotment on preferential basis private placement rights issue basis have already been made during the year, both in terms of number of securities and price. Details of significant and material orders passed by any regulator, court or tribunal impacting the going concern of the issuer and its further operations. Allotment made in 1 year for consideration other than cash. Report in respect of valuation of security. Justification for allotment proposed to be made for consideration other than cash along with the valuation report. Terms of raising securities, duration now if applicable, rate of dividend or rate of interest, mode of payment and repayment, proposed schedule for which the offer letter is valid, principal terms of assets charged as a security if any, and pre and post issue shareholding pattern. So these are all the different things which are required to be checked before filing. Then explanatory statement for shareholders resolution. The shareholder statement to the notice of shareholders resolution in relation to private placement should include the following particulars of the offer, including date of passing of board resolution, kind of securities offered, and the offer price, basis of justification for the offer price, name and address of the valuer who has done the valuation, and amount being raised through the private placement. So these are the all the statements which are required for from the shareholders for passing a resolution. Material terms of raising securities, proposed time, schedule, purposes or objects of the offer, contribution being made by the promoters or directors either as a part of the offer or separately in furtherance of objects, the principal terms of assets charged as securities. However, in terms of the proviso to the Rule 13(1) of the company's share capital and debentures rules 2014, the price of shares to be issued on a preferential basis by a listed company is not required to be determined by the valuation report for a registered valuer. So these are the provisions regarding the filing. Next, we shall be studying new penal provisions. Now, these are the penalties or punishments which are imposed. Penalties. If return of allotment in Form PAS 3 is not filed within 15 days from the date of allotment of securities, the company, its promoters, and directors shall be liable to a penalty of rupees 1000 for each day of default, and it is kept at rupees rupees 2 lakh 20 rupees 25 lakhs. Further, for a non-compliance of a private placement provisions, now the penalty restricted at the amount raised through the private placement process of rupees 20 of rupees 2 crores, which is lower, whichever is lower. Earlier the penalty imposed was kept at a higher of the two amounts. So this is the punishment, or these are the penalties which shall be which the company shall be liable to pay if form PS3 is not filed within 15 days. Why are these provisions made so strict? These provisions are made so strict because there firstly there are chances of people committing fraud, and paying such a huge amount of penalty is very difficult for the people. So the companies act has seen to it that they make the provisions difficult for them. The prospectus issued by any public company must fulfill following conditions. It must be dated. A prospectus issued by, on, or behalf of the company or in relation to an intended company must be dated, and that date is unless the contrary is proved, considered that the date of publication of the prospectus. So, in this case, it must be dated means what? That when the prospectus is filed or when the prospectus is issued on behalf of the company, the date which is there shall be issued, and it shall be easier for everyone to understand that when the prospectus is issued and what was the date and year of issue, so that in case there is a default or fraud in the company, the members have a proof that this prospectus was filed this time and the fraud has been committed after that. Then it must be signed if prospectus is issued by an intended company. It must be signed by the proposed directors of the company or by their agents authorized in writing. Similarly, in case of existing companies, it has to be signed by the directors or by the agents authorized in writing. So it must be whatever is stated in the prospectus is true, has to be signed by the directors of the company or agents who are authorized by the company for the purpose of the prospectus. They have to sign, and the signature shows that they take the responsibility in case any action which is not mentioned in the prospectus has been seen. Next, with regard to prospectus, following points to be noted. Invitation to make or purchase means invitation to make subscription or purchase for cash, because the word subscription denotes taking or agreeing to take the shares for cash. Hence, a document which offers shares in exchange for shares cannot be termed as prospectus. So, what does this mean? That invitation to make a subscription or purchase means invitation to make. So what does this state? It means that whatever shares or debentures are to be purchased shall be purchased in cash, and they shall not be taken in exchange for shares or in exchange of debentures. So only when it is taken for cash it shall be stated as prospectus. Second, deemed prospectus. Any document by which an offer of securities for sale is made to the public shall be deemed to be prospectus issued by the company. So, deemed prospectus means any prospectus or any offer which is made by the company for the purpose of selling its securities, it shall be termed as a deemed prospectus. Deemed means assumed. Copy of prospectus to be filed in the register. A prospectus cannot be issued by or on behalf of a company without a copy thereof being filed to the register for registration. Means what? That a copy has to be firstly filed with the register and once it is filed and accepted by the register, only then the company gets an right or gets a permission to have the copy to be said as prospectus. In short, prospectus must fulfill two conditions. It invites subscriptions to share or debentures, or invites deposits, and second, such an invitation must have been made to the public. When is issue of prospectus not necessary? So when is the issue of prospectus not necessary? This is what is the next point we shall be studying. In the following cases, issue of prospectus is not necessary. It is a private company. A public company need not issue a prospectus of it prospectus if it is going to raise its capital from private sources. Firstly, if it is a private company. Secondly, if a public company if is trying to raise its capital through private sources. Then next we have registration of prospectus. Prospectus is required to be registered with the registrar on or before its publication. The copy of the prospectus must be signed by every person who is named therein as director or proposed director of the company or by his authorized agent. It must be stated on the face of the prospectus that a company of it has been delivered to the registrar for registration on or before the date of its publication. So, registration of prospectus is one of the important provisions because it is required for the registrar to know that whatever is written in the prospectus or whatever is being issued or whatever is being told to the public is whether it is fair or whether there are some misleading statements, and whatever whoever is responsible shall be signing the prospectus before filing it with the public. Following documents must be attached with the copy of the prospectus while submitting it to the registrar for registration. Written consent of the expert to issue of the prospectus. Experts includes an engineer, valuer, or accountant. So, what all documents shall be issued with the prospectus before registering with the registrar? Firstly, written consent of the expert about the valuation. Then second, in that case, it shall include any engineer, valuer, accountant, etc. A copy of every contract about appointment and remuneration of the managing director or manager. A copy of every material contract not being a contract entered into in the ordinary course of business. The written consent of the person named in the prospectus as auditor, legal advisor, attorney, solicitor, banker, or broker, etc., of the company to act in that capacity. A written statement stating the adjustments in respect of profit and loss account or assets and liabilities made in reports in prospectus with reasons for adjustment. So all these things shall be mentioned and shall be attached with the copy of prospectus before submitting it to the registrar. No registration without completing legal formalities. The register of companies will not register the prospectus if the above mentioned legal formalities are not completed. Legal formalities include submission of various documents mentioned herein along with necessary consent of the experts. So unless the all the consent forms are filled and all the legal formalities are done, the no registration of the prospectus shall not take place. So it is very important to firstly file and get the consent from necessary experts for the purpose of complying or completing the legal formalities. Then next we have fine for contravention. If a prospectus is issued without delivering the copy of it to the registrar or without the copy of delivered having endorsement thereon or attached thereto required consent or documents, in such case the company or any person who is knowingly a party to the issue of the prospectus will be punishable with fine ranging from rupees 50,000 to rupees 3 lakhs, and a person knowingly involved in contravention of the provisions of section 26 shall be liable for punishment with imprisonment for a term of up to 3 years or fine stated above, or both. It is to be noted that prospectus can be issued the moment it has been delivered with the registrar of companies. That means it is not necessary to till till the document is actually registered. At the same time, the prospectus must be issued within 90 days of its submission or filing with the register. Otherwise, the prospectus which has been already delivered to the register becomes invalid. No charge in contract without approval of members. A company cannot change the terms of contract referred to in the prospectus without the approval of members in general meeting by way of special resolution. A company which intends to issue prospectus must file an application for enlistment of shares with one or more registered stock exchanges. A draft prospectus is required to be submitted to Securities and Exchange Board of India for vetting so as to ensure adequacy of disclosure and compliance with guidelines of SEBI. Thereafter, an acknowledgement card should be obtained from SEBI. Subsequently, the prospectus should be submitted to the register. So these are the provisions, or this is the penalty which is applicable in case the prospectus related any contravention is created by the company. Next, we have shelf prospectus. Shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of further prospectus. When huge funds are to be collected for infrastructure projects, then in such cases issue size is generally large, and hence many a time securities are issued in stages spread over a period of time. In such cases, it becomes very expensive to file a prospectus. Each and every time in such a case, this new provision of is of great convenience. Its advantage is that each stage of offer of securities during validity of shelf prospectus, filing of prospectus is not necessary. As mentioned above, this provision of shelf prospectus is available to institutions and banks engaged in infrastructure finance. Though in above cases, prospectus is not required to be filed at every stage of its offer of securities during its validity, but in the subsequent stages, it is necessary to file information memorandum. Information memorandum means this shall contain basic information about the company, about the infrastructure, and every stage in which the securities of the company are offered. A company filing a shelf prospectus will have to file an information memorandum at the second and subsequent stages of issue of securities. This information memorandum should contain all material facts relating to new charges created and changes in financial position as have occurred between the first offer of securities, previous offer of securities, and the succeeding offer of securities. The information memorandum and shelf prospectus constitute the prospectus, and such prospectus must be issued to public at each subsequent stage of offer. So this was about shelf prospectus. About red herring prospectus we shall be starting in the next class.